today we are going to do the company law amendment. Actually, there is nothing. Probably if we sit and see, it is hardly a 10 minutes amendment. That's all. There is nothing major. But of course, the page is around 89 pages. Again, as I always tell you, it covers amendments from Jan 23 to May 31st, 2025. Now, what we need to start looking at is, start looking at amendments that have come from December 24 till let us take May 31st, 25. Between this, if there is any amendment, that is what will be relevant in this video. Before this, whatever it is there, we have already covered. Please watch June 25 amendment video. And then if you watch this, you will be covering the whole thing. Yes. So said that, let us completely start. So whatever is the amendment, I will directly go there. Yes, the first amendment that I need to tell you is, we have already made a video on that. What are the topics that is deleted? Again, I am telling you. Institute had given one amendment saying that what are the topics deleted from the chapters. So first I'll show it to you that only. Let us have a little syllabus clarity and then only go ahead, so that you guys will also understand what you guys are doing. So people, the topics that are removed: Chapter 10, Compromise, Arrangement, Amalgamation, Operation, Mismanagement, Class Action Suits are deleted. On this we have already made a video. Probably when you are doing in the class, the content might have been there, but as it's an amendment, it's a topic that is deleted, it's okay. Next one, people, the whole chapter 12, Inspection, Inquiry and Investigation. The whole chapter has been now removed. It has been moved to CS Professional in Compliance Management, Audit and Due Diligence. They have moved this chapter there. So entire chapter 12, you guys need not have to study. The next one is called, the next amendment is CSR. Again, the CSR whole chapter is deleted. But one thing I'll tell you, it's okay to watch CSR chapter still, because what have they said is this lesson is deleted and the topics, that is the CSR policy, CSR activities, CSR committee, these three topics are relocated in the same paper in a different concept, that is in chapter 18. They have just put it there. And see, the topic CSR expenditure, ongoing project, impact assessment are deleted from executive program. The concepts are already covered mutatis mutandis in ESG, that is in CS professional level. So the three topics that are required for you is CSR policy, CSR activities, every information with regards to CSR committee. Those three are there. Rest and all you guys can literally leave it. CSR policy, CSR activities, CSR committee. Only that you guys need to know. Clear? Now that is the syllabus removal. That's the first amendment I know most of you wanted. So keep that thing in mind and go. And yes. Rest of it, search for December. If it's December, it's there for you. Okay, what is amendment? Okay, this is an amendment. What is this? Okay, this is nothing but people, the company's prospectus and allotment of securities. This is related to people. If you remember, there was rule 9A of prospectus and allotment of securities. All public companies who is going for a public offer, or even if you continue with your existing company, you have to mandatorily issue your securities in demat form. That was a rule. This is for public company. Now this rule was introduced even for the private companies also. That was a new rule, that is rule 9B. Now they said even rule 9B, private companies also have to mandatorily issue their securities in demat form, except small companies. Now it was passed in 2023, but effective date they gave some time. Now that is what is the amendment. Provided further that a private company other than producer company, which is not a small company, so producer company, small company, leave them, as on 31st March 2023 may comply with the provisions of this rule by 30th June 2025. So this will be the implementation date. The effective date of implementation is that. So by then you guys have to convert your shares into demat. That is this amendment. Done na? So rule 9B, private companies will have to also convert their shares into demat form. That's the amendment. Okay, what else is amendment? You ask me if there is any other good amendment. There is one amendment, that's all, which is, you know, good enough for being asked. Rest of it is like, okay. Okay, now this is the amendment. Important. In SEBI LODR people, there was something called as Regulation 24A. What does 24A prescribe? 24A of SEBI LODR had prescribed us. This has come in chapter 9, but yes, in general, it is coming under SEBI LODR. Capable enough of being asked, remember and go. If you guys remember in auditors chapter people, there was a restriction. What is that? An auditor cannot be appointed for more than one term of 5 years if you are an individual. If at all you are a firm, you can be appointed for 5 years, 2 terms. If you would have studied in auditors chapter, rotation of auditors, if you want to reappoint them, there will be a cool off period of 5 years. Now cut copy paste will apply to secretarial audit report. This is the amendment number 1. What is that? If at all in a listed company, if you are appointing anyone individual as a secretarial auditor, they can be appointed only for a 1 term of maximum 5 years. If at all they are a firm people, they can be appointed for 2 terms of 5 years. That too, for the second term, you need to take shareholders approval. Sir, if you want to reappoint whether the individual or the firm, individual after 5 years, the firm after 10 years, if you want to reappoint them, there shall be a cool off period of 5 years. And remember people, today, there is something called as, I don't know if you guys have heard of this concept called as peer review. You guys have heard of it, peer review. Now what do you mean by peer review, sir? Peer review is nothing but people, whenever a company, meaning this is as per ICSI. See, peer review is nothing but people. Now I am a company secretary. Let us imagine I am a company secretary A. There is another company secretary B. Peer review is nothing but people. Company secretary B's job, work, his, you know, I would say, how is his skill set? All of these people should be checked by one more person. Now, when one CS is checking one more CS's work people, that is only called as what is that? Now, if at all there is one CS, his work has to be accepted, approved by another CS. Now imagine one firm comes and approves that yes, your firm is doing a good job. You guys are doing good. If one firm comes and approves another firm's job people, we call this only as a peer reviewed company secretary. Nothing but people. A peer review means what? Someone of your level, same status, meaning same designation, your competitor. They will come and review your work. This is a big concept, but I'm giving it to you in short. So why am I telling it to you today now here is, going forward for a listed company, not a random company secretary should come and be a secretarial auditor. Only a peer reviewed company secretary can be a secretarial auditor. If you are not peer reviewed, you cannot become a secretarial auditor. Yes, sir. Is this clear? And not only that, there is one more concept called as secretarial compliance. In secretarial audit, you guys will check all the laws applicable on the company. In the secretarial compliance people, you will check only SEBI related laws. So even a person who does secretarial compliance report also, that is also there is an amendment. What does that see here? The secretarial compliance report submitted to the stock exchange on annual basis is signed only by the secretarial auditor or by a peer-reviewed company secretary who satisfy the conditions. What do you mean by that, sir? Even I should also be a peer-reviewed company secretary. So only these people can take up the secretarial audit or secretarial compliance report. This is the amendment. Remember and go, important. So only a peer-reviewed company secretary can take up secretarial audit or compliance audit. Just a second, people. Okay, that's the amendment. Remember and go. Yes, sir. The next one is there is this amendment. You guys can ignore this because this is an amendment which has happened in accounting standards. We don't have that in our syllabus at all. So you guys can absolutely ignore it. It doesn't make any much difference for us. So it's absolutely fine. Yeah. Okay. Next one, the company's account, second amendment, May 2025. Okay. In this is again one more amendment, people. What is that? They have said, people, going forward, we used to call AOC 1 and AOC 2. AOC 2, we were giving details of related party transactions. AOC 1, we were giving details of subsidiary, holding a subsidiary company. So now what they are telling, we were giving this AOC 1 and AOC 2 like in a physical form. Now what they have done is, going forward, they are telling you these are e-forms. That's all. For you guys, it will not make much difference. But in real life, it is no longer a physical form. It will become a e-form. That's an amendment. Next one, sir. Following mention, additional details shall be given with a statement that the company has complied with provisions relating to the constitution of internal complaints committee under sexual harassment of women at workplace. Now, what is that, sir? Now, when we are giving our, the board's report, people, we need to give an additional, undertaking. We used to say in a year how many complaints we have received. We used to say how many we have redressed during the year. What is the number of cases pending we used to give. In that, they have added one more. What is that? You have to give a statement that in my company, we have formed a internal complaints committee. Internal complaints committee is nothing but, people, tomorrow if there is any sexual harassment cases, they should be able to file it in one place. No, that place, that committee which takes care of that is called ICC. We will form it whenever we have 10 employees. Yeah, more than 10 employees. If we have it, we will form it. Yeah, so you should say that it is applicable and hence we have formed it. That is the amendment. And not only that, there is one more thing also. What is that? Also that additional detail in form of a statement with the company with respect to compliance to the provisions relating to Maternity Benefit Act has to be served in the board report of the company. What do you mean by that? I have to give one more additional declaration that we have complied with Maternity Benefit Act. What do I mean by that? If at all there are any pregnant women in our company, we have followed with all the applicable laws, we have taken care, and there is no non-compliance. We have to give a declaration. This is one amendment. Okay. Next one, sir. If you guys remember, people, in AOC 4, we used to give certain attachments. What was attachment, sir? We used to attach auditor's report. We used to attach board's report. We used to attach auditor's report, which was consolidated. Meaning consolidated means what, people? Which is taking care of all your subsidiary holding and all of that put together. We used to give this as an attachment to AOC 4. No, now they're telling you this will be filed as a separate form. So now this will also be called as e-extract. You will be filing it as an electronic form separately. That is auditor's report, board's report, and auditor's report which is consolidated. We will be filing it separately. That is what they have said here. Shall also file e-form, extract of board's report, extract of auditor's report, and extract of auditor's report consolidated, as the case may be, shall also be in e-form. Now, why did the MCA do this, people? Because you can imagine all of this was going as an attachment to AOC 4. You can look at the size of the form. Now at times people were not able to file it properly. So what used to happen? People used to compress it and file. So the data was not evident. The purpose only itself is not solved. So for that they brought this amendment. So now it is going to go as a different sub extract. We still file it, but we file it as a E form. That's the amendment. Next, if you ask me, those were the major amendments. Of course, chapter 12 itself is deleted, so all the amendments are no longer relevant for us. I hope your preparations and all are going good. I hope everything is on track. Nothing is, you guys are not finding anything difficult as such. The next one is called as people. What is this? This is to inform that all the stakeholders, again people what? We were following something called as MCA 21. We were following something called version 2, V2. Now people, we are migrating to something called as V3. So now the amendment is on that people that there is a migration of website. Now when this migration is happening, what we used to do, CSR2, we used to file it as an attachment to AOC4 and things like that. Now they are telling you can separate file e-form CSR2 just like board's report. So one is migration, that is one amendment. Second one is you can file form e-form CSR2 as a separate thing. Now what does it say here? Effectively allowing for independent filing of e-form CSR2. Whereas by notification dated 30th May version 3 version of annual filing and related e-forms including CSR2 as an e-form linked to AOC4 have been notified through the companies. Now keeping in view that the MCA V2 system will be decommissioned, meaning we will not be using it anymore. It has been decided by the competent authority that the stakeholders intending to file e-form CSR2 as an independent form can file the same in V3 portal. Going forward, you have to file it in V3 portal. This is from 14th July to 15th August. Yes, so we are filing it as a physical form. Now even that is also a e-form. Nothing major, but yes, that's the amendment. What else is the amendment? What else? Last one should be in KMP. Okay, KMP chapter, this is the last amendment. Now what is this, sir? Going forward, people, we have seen in multiple places, right? Every listed company should appoint someone as a compliance officer. That we knew. Now compliance officer, who was a compliance officer? Regarding that, people, they have given one thing. What is that? Going forward, people, the compliance officer of a listed company, he should be a whole-time employee. Part-time and all no longer possible. This person should be a whole-time employee. And remember, people, he should not be, where do you appoint him? Not more than one level below the board. Not more than one level below the board of directors. So he should be a senior person. You cannot appoint someone junior and you cannot call him as a compliance officer. And remember, you should designate him as a KMP. So a person who satisfies all these three, only that person can be appointed as a compliance officer. So going forward, people, you cannot have someone who is very junior and all appointed as a compliance officer. He should be a whole-time employee. He should not be appointed more than one level below the board, and he should be called as a KMP. So therefore, one level below the board means one level below the managing director or whole-time director. So you should be reporting to them maximum who are part of the board. In case a listed entity does not have a MD or a whole-time director, then what to do? Then you have to treat it as CEO, not more than one level below the role of CEO or manager or any other person heading the day-to-day affairs. Below them, maximum one level. It should not be less than that. This is the amendment in KMP chapter. That's all. And finally, go up to the last. There is one amendment there. That's all. Again, ignorable amendments, but yes. Again, CPACE we are done, if you guys remember. The same thing they are telling again. But what is that? We can just read it once. CPACE was established by MCA on 23 March, very old one, and to centralize and speed up the strike-off process in fast-track mode in order to facilitate ease of doing business. Since its inception, 13,560 companies have been struck off under section 248(2) through ROC CPACE in the financial year. See the good one. They were able to strike off around 13,560. The average time taken has come down to 70 to 90 days. So which was taking literally a year, they have reduced it to 70 to 90 days. Wide notification dated 5th August 2024, the ministry has centralized the striking off of LLP by empowering CPACE for processing e-forms. So if you ask me, not required, because LLP, we don't have it also. Yeah. Nothing important, people. Small company, 4 crore, 40 crore, and all that turn is there, people. They have now introduced small LLP concept. Nothing new, people. It's the same. Yes, this is new. Now, what is this here? Government has launched many initiatives to support women. Already, you know one initiative which supports women. Which one? Companies Act. One women director. Whenever a paid up share capital of 100 crore or more or turnover of 300 crore or more, they will mandatorily have to appoint one women director. That's a women empowerment only now. In addition to that, they have added more themes. What is that? This does not come under Companies Act, but casually they have given. To support women entrepreneurs under credit guarantee scheme for MSME, additional benefits has been given to the women than to the other entrepreneurs. Compared to everyone, we give more and more. I would say what priority to women itself. They men know what we should do. Under Prime Minister Employment Generation Program, which is a major credit-linked subsidy program, money given, in which the substantial beneficiaries are women who are provided higher subsidy when compared to non-special categories. Meaning what, people? When compared to men, they are getting higher subsidies. Chance of you getting more loan also, chance of you getting a reasonable rate of interest and all of that. Stand Up India scheme has the objective to facilitate loan from scheduled commercial banks. Banks are giving you. The values of the loan can be anywhere between 10 lakh to 1 crore. It should be now. See, this is what and all policy. To at least one SC, ST. You have to give mandatory loan for every branch. They have to give loan for one SC or ST. And one SC or one ST, and one women borrower per bank branch for setting up greenfield enterprise. Greenfield means what? Starting up a new company or an entity. To support that, the loan has to be given. An initiative, namely Yashaswini, was launched on 27th June 2024, which aims to campaign for women entrepreneurs and empower women by building their capacity with a focus in Tier 2 and Tier 3 cities. The Code on Social Security and the Code of Wages 2019 have provisions regarding maternity benefits and non-discrimination on grounds of gender respectively. Meaning, the new labor code, they have more maternity benefit acts and gender equalities. The Sexual Harassment of Women at Workplace provides a legislative framework for preventing of sexual harassment. I told you also, committee. The Act provides for constitution of internal committee where the number of employees is 10 or more, and also mandates for constitution of local committee by the district officer notified under the Act to deal with the cases of workplaces where the number of employees is less than 10 or when the complaint is against the employer itself. Now, what is this, people? For a company having 10 or more employees, you should have something called internal complaints committee, that internal committee. Now, what if less than 10? Then they are telling you, do one thing. In your district, there has to be one committee. That is only called as local committee. Yeah, the district officer will lead it, local committee. Why? Because for the companies having less than 10 employees, or let us imagine we have a sexual harassment case against the employer only. We can't go and complain it to him only. No. Such cases will come and be complained to this local committee. In order to provide for centralized platform for details of internal committees and local committees available in the country, as well as for providing a platform to the aggrieved women to file her complaint. So she should be able to file a revamped version of sexual harassment electronic box, also called as She Box, was launched by government. This is an effort for the government of India to provide a single window access to every woman, irrespective of her work status, whether working in organized or unorganized, private or public. If you guys have a complaint, you can go and register there. Under the Maternity Benefit Act, every establishment having 50 or more employees shall mandatorily have creche facility, meaning people to take care of your children. To facilitate working mothers in giving due care and protection to their children, Palna, a centrally sponsored scheme, was introduced in the April 20. Not so important, people. They'll not ask you. Next one, sir. SEBI has introduced industry standards. SEBI has introduced industry standards for minimum information that the listed entities are required to provide to the audit committee and shareholders for seeking approval. That is the amendment. What is that? Now, people, there were certain industry experts who went and asked, you know what, the related party transaction, whenever it is ordinary course or beyond an amount, we have to take audit committee approval, we have to take shareholders approval, as the case may be. We have to do one thing, we have to mandate certain information that the company has to give to take this information. They cannot just give on the face of it. So regarding that, people, they are going to come up with a guideline. Which one? These forums, the industry standard forums, ISF, which comprises of 3 people, ASSOCHAM, CII and FICCI. Now they are telling they will come up with the industry associations and stock exchanges will publish these standards on their website to facilitate a uniform approach. So whenever going forward, if you want to do any related party transaction, you have to mandatorily give these information to get the approval of audit committee and shareholders. These information is mandatorily to be given. Next one, what is this, sir? Okay, again V3, what is this here? Again CPACE only. Not very much important. Government has launched multiple digital initiatives for transparency and efficiency, reducing compliance burden in corporate filings. To prevent fraudulent filings, web-based online forms have been introduced in V3. We saw incorporating field level validations and auto pre-fill, meaning people, without that you cannot go forward. The form does not allow you only. In physical, people used to do all the matlabs. Now we have no board report and all. Furthermore, multi-factor authentication has been implemented to verify the identity of the users accessing the system. So multi-factor authentication like OTPs. Who can access? Not everyone. Additionally, measures such as masking private information from public view have been adopted to ensure the confidentiality and integrity of the data. Blur. Wherever it's a private information, those things will be blurred. The ministry has introduced several digital initiatives to enhance transparency, efficiency, and quickness in service delivery for reducing compliance burden and enhancing user experience. A few are listed below. One is CPACE, which we already seen. Next one is CPC. CPC was what? Centralized Processing Center. All your incorporations and all will go there only. It will be managed at central level. The MCA portal mobile app offers stakeholders seamless access to various services available. Like for example, you can check the BEAR Act and all. The chatbot serves as a unified communication channel, like a healthcare. The e-adjudication system, nothing but tomorrow if you guys want to have any, imagine you have any dispute, RD, ROC, if you guys have to do any adjudication, that can happen in electronic form only now. Stakeholders can also raise tickets on MCA 21 portal to provide feedback and report grievances if any regarding the challenges faced. Now we can do it. All old only people. It is not required for us, but yes, there were the migration was happening from V2 to V3. Now last final set of 38 forms are also now introduced in V3. It is a new website, not required for us. You can ignore. Yes. So these are the amendments, people. Nothing major. Just know and go that secretarial auditor part. Rest and all is absolutely ignorable. So that's it from today's end, people. Thank you so much. Wish you guys all the very best. Make the maximum use of it. Probably in 3 or 4 days time, I will try to come up with one video which can speak about the most important topics that you guys can cover from your exam point of view. I'll try to do a video on that. So yeah, let me know if that would help. If yes, do let me know, then I will definitely look at it. Yes, thank you so much. See you all. Bye bye.